In 30 years on this bench, a sitting governor has never walked into my courtroom, delivered a 4-minute speech about the separation of powers, and then stood up and walked out rather than answer a single direct question. That happened on a Tuesday morning in November, and the question he could not answer was 11 words long. If you believe that the people making decisions about children's lives should be able to answer a question about those children, stay with me for every word of this. Subscribe right now, because what I am about to share is the most consequential civil hearing I have presided over in 30 years on this bench. It does not begin in the courtroom. It begins 6 weeks earlier on the 4th floor of Mercy General Hospital, in a plastic chair outside a room where an 11-year-old boy has just been told that the surgery he needs to walk without pain has been denied for the 3rd time in 14 months. Hospitals place those chairs in corridors for people who need to sit down after receiving news they were not prepared to carry. Rosa Delgado was sitting in one when I first learned her name. She is 44 years old. She teaches art to 3rd graders at an elementary school 12 minutes from that hospital. She earns $31,000 a year. The surgery her son Diego needs costs $67,000. Diego has been on crutches since he was 9 years old. The denial letter that arrived after the 3rd review cited 2 words: budget realignment. 2 words that do not bleed, do not limp, do not sit in plastic chairs outside hospital rooms on a Tuesday afternoon. The budget realignment that produced those 2 words was authorized by Governor Charles Whitfield, 2 terms in office, state party chairman, the kind of elected official whose approval ratings are managed like a financial portfolio and whose office does not return calls from people in the circumstances Rosa Delgado was sitting in when she made hers. 3 weeks after the 3rd denial, Rosa filed a civil claim against the state's Medicaid Administrative Office for wrongful denial of medically necessary treatment. No one would take the case. Carmen Reyes did, 29 years old, 2 years out of law school, working pro bono from a legal aid office that shares a single printer with 4 other active cases. She took it because the medical record was clear and because someone had to. 4 days before the scheduled hearing, the governor's office contacted the court, requesting an indefinite delay, framed carefully in their letter as a scheduling accommodation. I scheduled the hearing as originally docketed, and on a Tuesday morning, the governor arrived. He did not enter through the public entrance. Governor Charles Whitfield arrived at the courthouse in 3 vehicles: 2 aides, 1 communications director, and a legal team of 5 attorneys from the firm that has represented the state's executive office for 11 years and billed it $4.2 million last year alone. He used the side corridor, access reserved for court personnel, which he had arranged through the courthouse administrator without notifying me. It was a small thing. It was also a precise thing. The choice of a man who has spent 11 years making sure that every room he enters has been prepared for him before he walks into it. He took his seat at the respondents' table as though this were a meeting he had called, rather than a proceeding he was required to attend. His legal team arranged itself around him with practiced efficiency. His communications director positioned herself in the gallery, 2nd row, phone already in hand. Rosa Delgado and Carmen Reyes were already at the plaintiff's table. Diego was in the 3rd row of the gallery. His crutches leaned against the seat beside him. His school backpack was on his lap because his mother had told him to bring his homework in case the hearing ran long. I entered at 9 a.m. and called the session to order. Before I could open the docket, Harrison Polk, lead counsel for the governor's office, a man whose billing rate is worth roughly what most people earn in a month, rose and informed the court that the governor's office had initiated a comprehensive Medicaid review process and that the appropriate resolution was a continuance of no fewer than 90 days. I did not ask Polk my first question. I asked it of the governor directly. Governor, Diego Delgado has been on crutches for 2 years. How long does your review need? In the second row, the communications director reached for her phone. The governor's expression did not change. I turned to Carmen Reyes. Counsel, please present the case. Carmen Reyes stood at the plaintiff's table with the specific stillness of someone so thoroughly prepared that there is nothing left to be nervous about. She was 29 years old. She had been practicing law for 2 years. She was working this case without $1 of compensation. None of that was visible when she began to speak. She presented 3 independent medical opinions. The first 2 came from surgeons on staff at Mercy General. The third came from a pediatric orthopedic specialist at a major research hospital whose name I recognized from 2 previous cases in which her testimony had been the deciding factor. All 3 opinions reached the same conclusion, stated in different language, but identical in substance. Diego Delgado's spinal surgery was not elective. It was not safely deferrable. It was not subject to legitimate clinical dispute. It was, in the documented medical judgment of 3 independent specialists, necessary. Then Carmen placed the state's own Medicaid clinical guidelines on the record. She put them side by side with the 3 denial letters. She went through them line by line, not quickly, not dramatically, but with the patient precision of someone who has read these documents enough times to know exactly where every contradiction lives. Each denial letter contradicted the guidelines it was required to apply, not as a matter of interpretation, as a matter of documented, provable fact. Harrison Polk's team raised objections at 4 separate points. I noted each one for the record and overruled it. Polk noted his objections to the overrulings. I noted those as well. Carmen did not pause for any of it. She simply continued. And then she placed something on the record that I will remember for the rest of my time on this bench. A graduate student in public health at the State University had spent 14 months studying Medicaid denial patterns across the state as part of her doctoral dissertation. She was not a lawyer. She was not an advocate. She was a researcher following data wherever it led. Where it led was a spreadsheet. Carmen had obtained it through a public records request and entered it into evidence that morning as Plaintiff's Exhibit 7. The spreadsheet had 2,847 rows. Each row was a child. Each row represented a medically necessary pediatric procedure denied by the state's Medicaid review process in the 3 fiscal years following the governor's budget realignment. Carmen presented the key finding without commentary, because the finding required none. Denial rates for medically necessary pediatric procedures in this state had increased by 340% in the 12 months immediately following the budget realignment. In neighboring states with comparable Medicaid populations and comparable pediatric health needs, denial rates for the same category of procedures across the same period had remained stable. 2,847 rows, each one a child, each one a denial, each one traceable through the data to the same budget document. Harrison Polk rose immediately, objected on foundational grounds. I overruled it and entered the spreadsheet into the record in its entirety. Polk requested a 15-minute recess. I denied it. He sat down. Governor Whitfield leaned toward Polk and said something quietly. In the second row, the communications director had both thumbs moving across her phone screen and had not looked up in several minutes. The room was very still, and then the governor stood up. Not his attorney, the governor himself. Governor Charles Whitfield had spent 11 years learning how to fill a room. Not with volume, he was not a loud man, but with the specific weight of authority that operates below the threshold of argument. The tone that does not invite response. The tone that communicates that what is being said is a conclusion being delivered to people who will act on it. He had used it at fundraising dinners. He had used it in legislative sessions and budget hearings, and press conferences where questions he had decided not to answer were asked anyway, and simply absorbed into the silence that followed his non-answers. He used it now. He told the court it did not have jurisdiction to adjudicate executive budget decisions. He said the separation of powers doctrine places Medicaid allocation policy within the exclusive purview of the executive branch. He said a civil court judge presiding over an individual claim does not have the standing to conduct what amounts to a statewide policy review. He used the word standing 3 times. He used the word purview twice. He spoke for 4 minutes without once looking at Rosa Delgado, without once looking at Carmen Reyes, without once looking at the 3rd row of the gallery, where an 11-year-old boy was watching him from behind a school backpack with the patient attention of someone who has been waiting a very long time for something to happen. I let him finish. Every word, all 4 minutes, every sentence. The courtroom held completely still when he was done. Not the stillness of agreement, the stillness of a room waiting to find out what comes next. Then I asked him the question. 11 words, the same volume I use for everything in this courtroom. No gavel, no pause for effect, no change in tone to signal that what was coming was different from anything else this bench had said all morning. Governor, of the 2,847 children in that spreadsheet, how many have you met? Governor Whitfield opened his mouth. The room was so quiet that the sound of him drawing breath was audible from the bench. He closed his mouth. He opened it again. What came out was not an answer. It was not the beginning of an answer. It was the specific, unguarded sound of a man who has spent 11 years in rooms where that particular category of question is never asked, and who has just discovered, with no preparation and no one positioned to intervene, that this is not one of those rooms. In the 2nd row, the communications director stood up. At the respondents' table, Harrison Polk rose simultaneously. 2 of the 5 attorneys began gathering documents with the brisk, practiced efficiency of people executing a departure that has become necessary faster than anticipated. Governor Whitfield straightened his jacket. He turned, not to me, not to Carmen Reyes, not to Rosa Delgado, and said to Harrison Polk quietly that his office would be addressing this matter through the appropriate channels. Then he walked out. The courtroom watched him go in silence. Diego Delgado watched him go from the 3rd row. Rosa Delgado did not watch him go. She was looking at Carmen Reyes. Carmen Reyes was looking at me. I ruled from the bench. I want you to hear every word of what I ordered. Wrongful denial of medically necessary treatment, supported by the record in its entirety. 3 independent medical opinions. The state's own clinical guidelines, contradicted by the state's own denial letters, line by line, 3 times over 14 months. A spreadsheet containing 2,847 rows admitted into evidence and standing completely unrebutted because the one person in that courtroom with the authority to challenge it had chosen to leave rather than answer a question about it. The State Medicaid Administrative Office was ordered to approve Diego Delgado's surgical procedure within 72 hours of this ruling and to cover all associated costs in full, not a portion, not subject to further review. In full, I ordered a formal compliance hearing in 30 days, at which the state would be required to demonstrate that its clinical review procedures had been brought into alignment with its own published guidelines. I referred the pattern evidence, all 2,847 rows, to the State Attorney General's office and to the Federal Centers for Medicare and Medicaid Services for independent review. Both referrals entered into the record. I noted for the record that Governor Whitfield's departure from this proceeding before its conclusion had been entered into the transcript and would remain there permanently. Then I called for the next matter on the docket. Diego's surgery was scheduled 4 days later. 11 days after that, he was discharged from Mercy General Hospital. He walked out, not on crutches, not with assistance. He walked out of that building on his own 2 feet for the first time since he was 9 years old, through the same 4th-floor corridor where his mother had sat in a plastic chair 14 months earlier, holding a letter that cited budget realignment as the reason her son could not do exactly this. Rosa was in the recovery room when he woke up. Carmen Reyes was in the waiting area outside with 2 cups of coffee and a folder of settlement documentation she didn't need, because the 72-hour order had already been executed and every cost was covered. The compliance hearing, 30 days later, produced a revised clinical review framework submitted to the court by the state without objection. The Attorney General's investigation ran for 8 months. The report it produced found a documented pattern of systematic misapplication of clinical criteria in the state's Medicaid pediatric review process across 3 consecutive fiscal years. Not isolated errors, not administrative inconsistencies. A pattern affecting thousands of cases, traceable to the same budget document. The report went to the state legislature. A special committee was convened within the week. Governor Whitfield announced 6 weeks later that he would not seek a 3rd term. The press conference in which he made that announcement did not mention Diego Delgado. It did not mention Rosa. It did not mention Carmen Reyes. It did not mention 11 words, or the silence where an answer should have been. Carmen Reyes received a phone call 6 weeks after the investigation concluded. She was offered a position at the state attorney general's office. She accepted it. Her first assignment was the Medicaid Compliance Oversight Unit, the division responsible for ensuring that the revised clinical review framework submitted to my court was being applied correctly, consistently, and in alignment with the guidelines it had contradicted for 3 consecutive years. The person who had documented 2,847 rows was now working to make sure the row count did not grow. There is a specific kind of justice in that symmetry that no ruling can produce and no sentence can order. It simply happened because Carmen Reyes decided it should. Diego Delgado is in the 6th grade now. He plays soccer on Saturday mornings at a field 4 blocks from Mercy General Hospital. He still has the backpack. Rosa is still teaching art to 3rd graders on $31,000 a year. This year, 3 of her students have had their own Medicaid procedure requests approved on the first submission. She mentioned that in a letter she sent to me. I wrote back, I keep a copy of that spreadsheet in the top drawer of my desk, not as a reminder of the question I asked. I do not need a reminder of that. I keep it as a reminder of what the question was actually asking, what it has always been asking, in every form it takes, in every case that comes through that door. Whether the people making the decisions have ever been in the same room as the people those decisions land on. I want to say something directly to everyone watching this. 30 years, thousands of cases, thousands of questions. The 11 words I asked Governor Whitfield that Tuesday morning were not remarkable for their complexity. They were not a legal trap. They were not designed to embarrass anyone. They were remarkable for one reason only. They required the person being asked to have done something before he could answer, to have been present, to have been in the same room even once as the consequences of his own decisions, to have met just one of the 2,847 children his budget had reduced to a line item. He had not. And I want to be clear about something. That is not unusual the way cruelty is unusual. It is usual the way distance is usual. The ordinary, unremarkable distance between the people who sign the documents and the people who receive the letters. That distance is not always maintained through malice. It is maintained through schedule, through staff, through the simple architecture of power, which ensures that the people making the decisions and the people living with those decisions almost never occupy the same room at the same time. This courtroom is one of the places where that architecture does not hold, where the person who authorized the denial and the child sitting in the 3rd row with a backpack full of homework are required to be present simultaneously, where someone is permitted to ask a direct question and the question requires a direct answer. That is not a remarkable thing. It is the only thing. The law is either the same room for everyone, or it is not a room worth having. If this story stayed with you, share it with someone who needs to hear it. Subscribe to this channel. because I have 30 years of stories from this bench, and every single one of them is about people who deserved to be seen. And picture Diego Delgado on a Saturday morning, a soccer field, 4 blocks from the hospital where his mother once sat in a plastic chair holding a letter that said no. The backpack on the sideline, the crutches gone, the game in progress.